I have with me a copy of the filing from the District Court for the District of Columbia seeking to compel the production of information relating to Prince Harry's immigration application into the United States. I also have with me The Sun and a can of Coke, not sponsored video, and some new channel members. So let's take a deeper look into this application. Welcome back to the channel. So I have with me not just this application, but I also have the exhibit behind it, and we're going to take a look at both. Let's take a look at the application itself first. I did touch on this in my previous video. It is an application to compel the production of information relating to Prince Harry, the Department of Homeland Security's decisions to admit Prince Harry and others into the United States and to allow them to remain. It goes on to say, as I said, this is of immense public interest, and there's a lot of information within this which I didn't get to see yesterday. It talks of widespread and continuous media coverage as to the question of whether the Department of Homeland Security properly admitted Prince Harry, in light of the fact that he'd publicly admitted to the essential elements of a number of offences, both in the United States and abroad, of course in the UK and other places. United States law, it goes on, generally renders such a person inadmissible for entry into the United States. Intense media coverage has also surfaced as to whether the Department of Homeland Security may have properly granted a waiver to enter the country on a non-immigrant visa, given the history of admissions to the essential elements of such offences. Finally, the media coverage has surfaced as the question is whether the Department of Homeland Security's decision to admit into the United States should be reconsidered in light of the most recent admissions to the essential elements of numerous offences in his memoir, Spare. It goes on quite some way to detail who the people are that it's seeking this information about and why. But it also goes into some background as to the United States' typical approach to these sort of offences, illicit offences and admissions to the United States. Congress has long deemed individuals who commit controlled substance violations inadmissible to the United States. When one is inadmissible, one cannot lawfully enter the United States, even if one has applied for and received a visa. So this is a differential between getting a visa and entering the United States. One who is deemed to have committed these violations. Although the exact prohibitions have changed over time, the bar applicable during all periods relevant reads as follows. Except as provided in Clause 2, any alien convicted of or who admits having committed or who admits committing acts which constitute the elements of the offence of a violation or conspiracy or attempt to violate any law or regulation of a state, the United States, or a foreign country relating to a controlled substance. So any state, anywhere in the United States, or indeed any foreign country, is inadmissible. The statute looks to the legality of the conduct at the time it occurred. So not looking forward, will you do this in the future? At the time it occurred, looking at the legality of what happened at that requisite time. For the purposes of this bar to inadmissibility, the fact of conviction or the admission of to the essential elements of a violation, controlled substance violation, are treated as interchangeable equivalents. So there's no distinction between the two, either admitting on the facts or the fact of a conviction are treated interchangeably. So as I said in my Popcorn Planet appearance yesterday, which you may have caught, I said it doesn't matter whether you've been convicted or not. This is not what this is looking at. It is asking someone making these applications to provide full and frank disclosure, we call it. They ask you a question, you provide all of the information that is relevant and pertinent to that question. However, the fact that dealing admitted his prior offences is no greater consequence than conviction itself, and So it's set out in case law as well. So this is upheld and solid law. It goes on explaining why that is all relevant, why that is a strong grounding. And then it talks of the form that I mentioned yesterday. Are you or have you ever been an abuser or an addict? And then for me, the more pertinent question here, have you ever violated or engaged in a conspiracy to violate any law, which is as I've just set out. Moving on, media questions concerning past applications to those seeking admission. Now, this is also something that I mentioned yesterday, that there has been extensive media interest in past applications of these sections to aliens seeking non-immigration admissions to the United States. This coverage has directly surfaced questions regarding whether the Department of Homeland Security is enforcing the law in a discretionary area consistently, impartially, or is showing favoritism, because the general public is not going to want favoritism, no matter who they are, as this will go on to explain quite starkly. Put differently, the coverage is focused on the fact that because the Department of Homeland Security has a discretion in this area, it is critical to know that such discretion is being properly exercised. Well, of course, if we entrust any department, any individual, any body with a discretion over a given area of law that affects a lot of people, clearly there is a general interest for people to know that it's being properly exercised. News media has extensively covered the issue and explained that even prior use, regardless of whether that was legal in the state within the US or in a foreign country, can cause a foreigner to be banned from the United States. And it goes on, there are many prominent examples in which the media extensively covered whether the Department of Homeland Security or its predecessors properly applied the law. Mark Berry, by way of example, Isabella Brazier-Jones, this list goes on. Pete Doherty, Kate Falconer, Andrew Bell. This list goes on, and this is to show, as I said yesterday, there is significant interest and typically openness for transparency purposes. And I referred the late Amy Winehouse yesterday by one of example. And again here, talking about the clinic visit and so on. I won't go into full detail about that, but you can read that for yourself if you want to pause the video. So the press has reported extensively on immigration law experts warning of prospective immigrants and visitors that they could face difficulties if they admit to use. I am one such legal expert who has commented that this could raise significant difficulty having made those admissions, and at the very least to face questions and scrutiny, as is now the case with this legal filing. This reporting is also focused at times on other prominent British citizens, for example, and it gives another list. So this really goes on. Now, this then turns to a list of admissions of such offences, obviously in the memoir, and quotes various sections here. And each of these sections, I'm not going to read out chunks of it, but just some poignant bits of it that make very clear that this is not just a one-off, not just an accident, not just incidental, coincidental, but an ongoing behavior and a propensity to continue to commit. So in law, we very often look at, just pausing for discussion there, in law, we very often look at propensity. Now, I even did a pro bono talk, legal talk at a school during my training, actually, many years ago. And even the young children had come across the notion that similar offences can be used in court to show propensity to commit further offences or similar offences. Simply put, you've done it before, you're more likely to do it again. It's not automatic, and it depends how long ago it was. It depends how similar the facts were. But if they're on similar facts, similar grounds, not too long ago, and it's a serious offence, it's likely to be considered. If they're completely different and disparate offences, or so long ago that it shouldn't be fair that it's considered now, then they're not usually considered. So I gave the example. I believe one was to do with drugs and one was to do with criminal damage, and there was nothing linking the two. Completely separate offences, both in time, space, and factual basis. And this child of about 6 years old said, no, the court shouldn't consider the other offence. I said, why not? He said, well, it'd be unfair, because just because he did that doesn't mean he did this. And that's absolutely right. But the reverse is also true. If someone has done something before many times, they're more likely to do it again, generally speaking. So this legal filing picks up on this point, in my view, and says, while quoting and saying, I knew this was bad behaviour. I knew it was wrong. My mates knew it too. We talked about it often. How stupid we were to be wasting an Eton education. Eton, by the way, is a very expensive school in the United Kingdom, for those that don't know who may be abroad. Once we even made a pact at the start of the exam period called trials, we vowed to quit until the final trial, the final exam. But the very next night, I heard my mates and essentially carried on. So this details a lot of admissions and acknowledgement. As it says here, much of the admitted conduct occurred in England, and referring to extensive possession here. So this lists many such events to rely on for this application as to why this is relevant, necessary, and should be part of the application and should have been consideration for Homeland Security. And if not admitted to in the application, why they should now consider it. So as I said, each of these in support of this application make for a very strong application, in my view, which is going to put the court in a very difficult position. Well, it shouldn't put the court in a very difficult position. It's going to put the court in a position where it has no alternative but to make a ruling on this, and it ought to rule in accordance with the law. And the law says that each of these are a propensity, and if someone has admitted to this use, then they should either declare it on the application and then should ordinarily be denied or maybe removed. And worse still, if they didn't mention these, which are now admitted on their application, then that is obviously being untruthful to a public body for immigration purposes. And then it goes on here. Recall that under this section, the key issue governing admissibility to the United States is whether there was an admission to the essential elements of a controlled substance violation under the law of the country in which the conduct occurred. Here, England, the United Kingdom. This is our legislation in the UK, Misuse of Drugs Act, criminalises a broad array of conduct relating to these substances. And even quoting our own law back to the Department of Homeland Security within the body of this application to court. Section 5.1 provides, subject to any regulations under Section 7, it shall not be lawful for a person to have a controlled drug in his possession. And these are what we refer to as strict liability offences, much less actually being used. Just possession is a strict liability offence. And so, not that I do much criminal work in my practice, it's mostly commercial and company and consumer intellectual property and that sort of thing. But in my early days, I did certain cases of this nature, and they are very serious offences. So as I mentioned yesterday on my videos appearances yesterday, you can be looking at 4 years or more per each offence if they are deemed serious enough vis-a-vis quantity, Are you supplying it to anybody? Are you part of a chain? So very quickly, with a number of offences here, especially if they run consecutively rather than concurrently, you could be looking at 6 or 8 years. They are taken very, very seriously, these sort of offences, even just for simple possession by yourself, regardless of intent to supply. Moving back, this goes on to quote various other bits of legislation. It's an offence to have for a person to have a controlled drug, and so on. And so this makes, in my view, we're only about halfway through this first document here. You can see this has gone to some length to detail why this should be considered. Now, moving to the exhibit to take a look here. This is the original, the underlying Freedom of Information request. Now, I understand that it is similar in the United States as it is in the UK, in that if you're an individual, you can make an individual request to a company that holds your personal data for them to release your personal data to you for the purposes of enforcing data protection law. There are various rights with respect to data protection law. The right for it to be kept securely, accurately, only for as long as is necessary, only as much of it as is necessary, and it's only used for what is necessary and what it was originally gathered for, and so on. So you can make these requests to private companies, but a Freedom of Information request is subtly different in that public bodies that hold this information, either on you or on anybody else, you can request this information that is held publicly and should be disclosed under given circumstances. So this is the original information request as it reads here. Pursuant to the FIA and the implementing regulations, the Department of Homeland Security, I respectfully request the following records containing the following information that the Department of Homeland Security or U.S. Customs or Border Protection and Citizenship and Immigration Services have within its possession. So this is ultimately what this filing is seeking. All records with the alien file, the A file as it's known, of Prince Harry, including but not limited to any and all applications for immigration benefits filed, whether or not adjudicated, in other words, decided on. So any applications that have been filed, whether or not any decisions have been made in respect of those. Any and all of these forms, and these forms. Records pertaining to system and records maintained, automated targeting system, advanced passenger information system. I don't profess to know what all of these are, but they are clearly lots of different systems and databases where information is stored and shared for use for various immigration purposes. All records relating to any request for a waiver pursuant to Section 212 of the Immigration Nationality Act, including but not limited to email communications with Homeland Security Office. So all communication, any questions, presumably any questions to or from, and any responses to or from either department whatsoever. This exhibit again goes on. And so this is having now taken a look at it, is a robust application, in my view. It's heavily supported by previous examples of why they say that this information is relevant, why they say Department of Homeland Security should take this seriously, that it should be on the form, and if it's not on the form, that should be serious. And if it is on the form, again, they say why that should affect immigration status, both ongoing and initial admission. So with that in mind, I think this has taken a significant turn, in my view, in that it is sufficiently serious for a court to make a ruling. I would be, on the back of this, I would be surprised if a court didn't rule that all of this information should be released, save potentially for an order that has a caveat to say it should be released to special counsel for consideration or something like that. But I'm not versed enough in the US procedures to comment on that. Maybe one of our US law tubers can come back at me with that. But I'll be very interested to follow it up as and when any further information unfolds. And just before I let you go, I would like to say a huge thank you, not just to my existing channel members, but my new channel members since I last did this. Carol Clark, Gray 48, Michael Hawkins, Alabama Sparrow, Mr. Harry Marshall Brooks. Again, I think that's a rejoiner. Dr. Debo Cherry, David George, Stacey Richards, Ika Smitten, and of course, all of the long list of supporters, patrons, channel members, all of which are on the right-hand side here. So I'm very grateful to you all. Thank you for joining. You will find the join button below. I do try to filter all of my channel members' comments to the top, which informs my new videos and topics that I discuss. And feel free to join there and support me there. And in the meantime, I thank you for watching. Make sure you smash that like button before you leave and subscribe. And I'll see you next time.